Good morning. I am Lynn Leipold from Master Maintenance, and we are your premier building service contractor here in Detroit, Michigan. We have offices in Ypsilanti, Detroit, Ferndale, and Toledo, Ohio. We service commercial buildings, industrial buildings, medical buildings, residential, and really any building with 4 walls and a roof. Our services include janitorial, porter services, hard surface floor care, window cleaning, carpet cleaning. We have over 40 truck mounted units in southeastern Michigan. So we're able to respond to any water mitigation situation you may have. In addition, construction cleanup, move in and out cleanup, and we provide maintenance and repair nationally. Today, I would like to welcome you to an update on new developments in the marijuana industry in Michigan, an overview of current issues facing real estate professionals interested in commercial cannabis, presented by the one and only Karina Kratz and Caitlin Elias from Kitch Attorneys and Counselors. But first, a few housekeeping points. For those who have real estate licenses and did not provide it during registration, you do need to contact the BOMA office. Attendance will be monitored as it is required from the CE marketplace. Today's presentation qualifies for 1 legal credit, not 2, but 1. There will be a question and answer period at the end of the presentation. If you have questions during the presentation, please put them in the chat section. We hope to see you back at 3 p.m. for Workplace 2.0, preparing your building and workspaces for the return to work and beyond. Thank you to all of our mega educational sponsors, Brown & Brown Detroit, Marble Life and Grout Masters, and of course us, Master Maintenance. Now I'm happy to turn it over to Caitlin and Karina. Make it a safe day.
Thank you so much, Lynn. Thank you for introducing our presentation today. We're really excited to be here with you all. Before we get started, I'll just share a little bit. So I am a senior associate attorney at Kitch Attorneys and Counselors. I focus my practice on real estate and commercial law, and I also am part of the marijuana and hemp practice group. Karina, do you want to say a few things before we get started?
Yes, my name is Karina Kratz. I apologize if I sound a little hoarse this morning. I have no idea what's going on. But I am a principal with Kitch. I focus my practice on commercial litigation. I am also the head of the marijuana and industrial hemp practice here. I also have a background in intellectual property issues as well. So I participate in a lot of brand protection. And Caitlin, oh, and one thing that I really want to stress before we get started, if anybody has a question, please type it in the question and answer box. We will try to address questions as we're going, but of course there will be a question and answer period at the end. So if we don't get your question as we're going, I do apologize, but we will try to monitor.
Excellent. And with that, we'll go ahead and get started. So we're here today. There's a lot going on in the marijuana industry here in Michigan, and we're here today to focus specifically on issues facing real estate professionals. And there's a couple different avenues that real estate professionals can get involved in the commercial cannabis industry. So we'll try to address all of those different areas, and then like Karina said, we'll have time for questions as well. So the topics that we're going to try and hit today, first we'll just provide a very basic overview of Michigan's marijuana laws and kind of where we stand right now. We'll do a little bit of a review of the licensing process. We'll talk about really the big topic is, once a cannabis company is licensed, how do you find suitable commercial property and what those issues look like. We'll talk a little bit about our recommendations for the language that should be used in all different contracts related to commercial cannabis and real estate. We'll talk about some of the finance issues, and then we'll discuss insurance recommendations, trademarks, and then we'll have time for questions. So with that, I'll introduce a little bit about Michigan's marijuana laws. So actually in 2008 is when Michigan legalized medical marijuana. And so there was the Medical Marijuana Act, which really just allowed caregivers to grow marijuana pretty much in their homes. And you had to register and get your medical marijuana card. You had to be a patient who, had a relationship with a physician who recommended you as a patient to use medical marijuana for health purposes, and then you had a caregiver. But other than that, there wasn't a lot of information and regulations around growing and where you can grow and all that sort of stuff. So in 2016, Michigan passed the Michigan Marijuana Facilities and Licensing Act, which is often referred to as the MMFLA. And what that did is it formalized the system for licensing, regulation, and tracking of medical marijuana. It created 5 business licenses for medical marijuana businesses. Those licenses are grower, processor, provisioning center, secure transporter, and safety compliance facility. So you'll notice that there isn't a license for caregivers. So for caregivers, if you have any questions or things about caregivers, that is a registration process. So again, for a caregiver, you have to be a person, not an entity or a business. And so there's not licenses for caregivers, you're just a registered caregiver. You get a registration card. But for licenses, you have to be an entity, and these are for businesses. And again, this is important because it's the businesses that are probably going to be looking for property. In 2018 is when we legalized the adult recreational use here in Michigan. We passed the Michigan Regulation and Taxation of Marijuana Act. And what that did is it added additional micro business license and increased the grower license so that you can have up to 2,000 plants. So we have all the same licenses as before, the grower, processor, provisioning center, secure transporter, safety compliance facility, with the additional licenses for a micro business. So with the licensing process, so if you are a cannabis company, for example, before you can even get started, what you have to do is you have to get a state license, and then you also have to get a local or municipal permit. So what that looks like, it's very expensive to get your state license. It can take months, and it can be very expensive to pay the licensing fees. And then once you get your state license, then you have to get your municipal permit. Right now, there's approximately 900 municipalities across the state of Michigan that have passed ordinances opting out of recreational marijuana sales. So what that means is before you even can get a local permit, you have to make sure that the municipality has an ordinance that is acceptable for having cannabis companies within their locality. So it's a process. There's a lot of lobbying going on. There's a lot of lawyers that are dedicated exclusively to working with municipalities to craft their local ordinances to opt in. And of course, there's many city councils across the state that are choosing to opt out and not have any marijuana sales within their locality. So within those participating municipalities, the number of available local permits is limited by both police power ordinances. So they can say they directly limit the number of permits that are allowed for grows, or they'll limit the number of provisioning centers they want in their municipality, or they'll limit the number of secure transport permits that they will give in their municipality. So they do it that way. And then the big thing, and for those of you paying attention to the city of Detroit and some of the bigger cities, the other way that these city commissions and city councils are limiting the number of available local permits is through zoning. So they'll implicitly limit the number of compliant locations through zoning restrictions and setback requirements.
And one other thing to add, and just to keep a lookout for, is that we are seeing a lot of, as Caitlin mentioned, like lobbying or groups who are crafting ordinances and putting them on local ballots. And those ordinances, while the language may not always be, I'll say, distributed to the public in a manner that is easily obtainable, Some of these ordinances are being voted in because people either want to allow marijuana for tax revenue or not. And we're seeing that sometimes these ordinances can be quite favorable to certain types of entities or certain groups. And so that's just another thing to keep in mind of what type of ordinances are in the municipality that you're looking at, and does it favor one side or not, and if that municipality is trying to take action regarding that ordinance.
Yes, exactly. So I had mentioned, how through the police power, some of these municipalities are limiting, the number of permits. That can vary. So there's, some municipalities that they only want, 5 grow, but they'll have unlimited secure transports or things like that. So depending on the type of cannabis license you want to get, that'll also depend on where you're going to be able to grow the business. So for real estate professionals, maybe you're a landowner or you're a building manager or you're a broker. The big thing that you're going to want to pay attention to is figuring out, especially with the zoning laws, where you might have current property that all of a sudden becomes zoned in a green zone. And so the things that cannabis companies are going to be looking for is trying to make sure that they're compliant with both the zoning laws and then also that you're trying to get one of the permits. Some of the factors that limit the type of commercial property that's available to these cannabis companies is first, stick buildings, utility access and capacity limitations, distance from retail outlets, and for retail facilities, distance from an adequate customer base. And so what that looks like is, for example, some of the more rural areas are passing ordinances that have that have unlimited licenses for certain types of cannabis companies. And that's great. There's not a lot of competition then to try and get in there. But what that looks like for some of the businesses is actually when they open, maybe they're not getting the type of revenue and income that they're looking for because they are in a rural area, so they're not getting the type of customer base that they need. Things like, distance from other retail outlets. You need to be very aware of how your business is going to affect other tenants in a strip mall or other tenants in the surrounding properties. That's a concern, especially like if you're a grow facility, there might be some odor and just increase in water usage and utility usage that you want to make sure that all of those properties have the adequate access to the different utilities that you're going to need in order to run the business. So what this looks like now, so we're getting this like limited pool, right, of properties that are properly zoned in an area where, there's a number of licenses that can really allow for a number of cannabis companies to come in. And then you also, within that area, looking at the actual suitable types of commercial properties that are available, and you get this shrinking number of properties that then become available to these cannabis companies. And what that means is the purchase prices for these regulatory compliant, structurally significant, structurally sufficient, and commercially viable properties equates to a purchase price that is several times greater than might otherwise be the case for non-cannabis uses. So an example would be an abandoned gas station that sells for $3.5 million. These property values then surrounding the cannabis businesses also tend to rise. So if you're looking, from two different vantage points, if you're the buyer, the goal is to secure suitable property without having to close the transaction until after you've gotten your local permit and the state phase 1 pre-qualification approval, right? Because you don't want to buy a piece of property that might have this inflated purchase price and then not even get your local or state permits that allow you to then open your business. If you want to find the property but not close until after you've secured all of your licenses and permits. For the seller, the goal is to ensure that the property is purchased contingency free, or alternatively by a buyer who is likely to secure a local permit and state approval and close the transaction at that inflated purchase price. So depending on what perspective you're coming from, there's different goals when you're securing that suitable property, but those are some of the issues that we're seeing within the real estate market. So for contracts, there's, a lot of, I guess, the questions that I get pretty often from maybe landowners or people that are looking to lease out different commercial property is, how can I be a landlord? And, I'm not involved in the cannabis business, but I just want to lease it to a cannabis business, and I want to be fully protected from any type of prosecution. Again, as all of you, I'm sure, are aware, cannabis still remains illegal at the federal level. So there is still some risk involved in, engaging in the cannabis industry. And so what we've found, and what usually, gives enough fodder to the feds to kind of, not really go after or prosecute landlords or people that are involved in the cannabis adjacent aspects of the cannabis industry, is really being upfront and honest and very clear in all of your contracts, things like the purchase agreement, things like lease agreements, including language that is that recognizes that both parties are very aware of what's going on in this transaction, the fact that the property is being used for a cannabis business and marijuana activities. So things like including disclaimers, such as the one on the screen that says, this agreement is subject to strict requirements for ongoing regulatory compliance by the parties hereto, including without limitation, requirements that the parties take no action in violation of the MMFLA, MRTMA, collectively referred to as the Act, or the guidance or instruction of the Michigan Marijuana Regulatory Agency, including any successor governmental authority, also known as the regulator. And then you can point to certain sections in the lease agreement that contain specific requirements and commitments by the parties to fully maintain their respective compliance with the Act and the regulator. So what this does is it provides enough, transparency to anyone reviewing the lease agreement that indicates that both parties are aware of the use of the property, and that both parties are committing to fully comply with all of the Michigan marijuana laws that are in place. There's reference to the Michigan Marijuana Regulatory Agency, the MRA, which is currently the agency under the Department of Licensing in the state of Michigan that puts out all of the Michigan marijuana regulations. They're the ones that issue the state licenses. And so I'm indicating that both parties are committed to being in full compliance with all of the guidance issued by the MRA and fully complying with all of the laws within the state of Michigan is really something that we highly recommend.
Another disclaimer or clause that we'll often include in some of our contract language is also an acknowledgement that that anything to do with marijuana is still federally illegal. And what we have found is that a lot of the entities who are established and aren't just new and getting the game or kind of like a fly-by-night company, they're well aware of this, and everybody's well aware of it, one, but they acknowledge that type of contractual language where they'll say, yep, we do know that this is federally illegal, and then we're not going to use that as a basis to try to rescind the contract or say that the contract's void or anything like that. And we're seeing that in not only different types of licensing agreements, but also landlord-tenant agreements, any kind of commercial agreement. Having that type of language is important, because then if something does happen on a federal level, granted we're seeing different attitudes toward it now potentially, is having those types of acknowledgements are very important. So you have them not only on the Michigan level where the tenant, for example, is agreeing that, hey, they're on the hook for complying with all the Michigan laws, but then both parties acknowledge, hey, this is still federally illegal, but we're not going to use that as a basis to try to rescind the contract and get out of it and say, hey, nope, never mind. I don't want to be a part of this because I breached my lease or whatnot.
Yeah, and to be clear, we can include language in lease agreements that say, when if the tenant should fall out of compliance with the laws, if they should lose their license, things like that, that can be a basis for terminating the lease. We can also include language that indicates that should there be any type of federal investigation, if the DEA shows up at the property and decides that they want to raid the property, that the landlord, the tenant completely indemnifies the landlord for anything related to any type of federal investigation. So there's a lot of language that we can include that does protect landlords while also acknowledging and being transparent in the language. Things like this follow-up clause. So really, again, acknowledging the fact that this industry is changing quickly and the laws and the regulations are changing quickly. I mean, almost every 6 months, there's a new set of regulations and guidance that comes out from the MRA. And so just kind of acknowledging that the rules that are in place at the time that the parties enter into the contract are subject to change and they're evolving. And that the parties hereby agree to use their respective commercially reasonable efforts to take all actions reasonably requested to ensure the compliance with the act, the regulator, and then as well as negotiating in good faith to amend, restate, supplement, and otherwise modify the agreement. So, over time, there might be certain amendments that are necessary. Additionally, there can be changes both at the state level and the federal level. So there might be certain things that we want to amend, along the way, especially if we're entering into lease agreements for, 3-5 years. A lot can happen in that time span. So including, language like this that is, flexible enough to indicate that the parties are going to continue to use all of their commercially reasonable efforts to continue to comply, but then also amend the lease or the purchase agreement as necessary. So specifically talking about leases, which is what I see a lot right now. So under the MMFLA and under MRTMA, which is both the Medical Marijuana Act and also the adult use laws, a landlord is not considered a true party in interest if it is receiving reasonable payment for rent on a fixed basis under a bona fide lease or rental obligation. So again, the question always in the legal world comes down to what is reasonable. And what we've seen, work or kind of across the board in some of these real estate transactions is looking at what the market rate is and then adding an additional 25%. That seems to be a reasonable basis. Again, it takes into consideration that the availability of suitable commercial property really is limited. So it places a higher value on the land that's available to these commercial cannabis businesses. And then we always recommend that you include escape clauses, like I mentioned, that specifically list out federal intervention, changes in federal enforcement policy, forfeiture threats, federal enforcement actions, like the DEA raids that I mentioned, like DOJ criminal charges or administrative actions, that these would constitute defaults under the lease. And then, the lease can be terminated for things like that. And then also the tenant would indemnify the landlord for any type of actions or occurrences such as that. Again, this kind of appeases the feds so that, the landlord really is seen as separate from the cannabis and marijuana activities. So another thing to keep in mind, a lot of these city ordinances, they might indicate, through zoning and through the number of permits that they're allowing, there's going to be further regulations, stating that dispensaries can only be open for certain hours during the day, indicating that you have to be very aware of the neighbors, the odors, any loitering, including clauses that address hazardous substances, talking about the number of people that are permitted on the property, and really making sure that you're stating that both the tenant and the landlord are going to comply with state and local regulatory rules. And the reason I bring that up is, a lot of the standard lease agreements that we see include indications of compliance with federal, state, and local regulatory rules. And as we've kind of been mentioning throughout this program, at the federal level, it still remains illegal. So really kind of paying attention to your contract language, your lease language, and maybe removing federal compliance as a requirement in the lease. It's important for the landlord to understand what the local regulations are, so that they can include that language in the lease, so that the tenant remains in strict compliance with the code of conduct for the property use. For example, there can be ordinances that indicate, parking, where parking is, and no street parking or things like that for cannabis retailers. So that's important. And really indicating that the use of the property is going to be for the retail sale of marijuana and other cannabis activities, and really forbidding actions that violate state law but not federal law.
And to piggyback on that, in being cognizant about federal law, it does get down sometimes into the nitty gritty as to who is actually the landlord and who's actually the tenant. Because if one of those parties is outside of the state of Michigan, for example, then you might have a federal interstate commerce issue of one entity is outside and the other one isn't. And so you really need to be aware of who everybody is and how they are going to be involved in the transaction.
Yes, exactly. So when it comes to finance issues, there's, again, because it remains illegal at the federal level, this largely is still a cash industry. And because of that, there's a lot that increases the security concerns. So, people know that these cannabis companies are operating primarily through cash, and so that can really bring a need, especially for, when you're looking and maybe you're a property manager, maybe you require in your lease agreement that the company is responsible for all security measures, and whatever that looks like, depending on the type of business. So maybe that's making sure in requiring the tenant to install security cameras around the premises. Maybe that requires, a gate, a 24-hour security guard, things like that. That's something to really be aware of, just because of the enhanced security concerns that come with being in a cash industry. Additionally, when you're talking about purchasing a piece of property and closing and things like that, not all title companies right now are willing to hold a deposit for a cannabis property. We do know some title companies that are willing to engage and work with the cannabis industry, but not all are. So an alternative sometimes can be, if a lawyer is involved with you and working with you on this transaction, perhaps the law firm holds the deposit. So things like that to be thinking of and aware of, and some of the hurdles that you're going to come up against when you try to engage in the cannabis industry. Additionally, for cannabis companies, because it remains federally illegal, most of these companies can't bank at federally insured institutions, so they're turning to state credit unions. So we do have some information, and we know some of the state credit unions that are working in the cannabis commercial industry. But because of that, and because of the restrictions that are in place and that these companies are facing, that in turn allows these credit unions to charge really high fees. So another hurdle in entering the cannabis industry is kind of all the additional fees that come along with working in a space where it still remains federally illegal. So we recommend, and it's especially helpful for tax purposes, say you're a landlord or a property manager that's used to accepting rent on behalf of the landlord, We really recommend that there is a separate account that is specifically set aside for receiving the rent from these specific cannabis entities. Don't commingle the funds, keep them separate so that in case there ever is any type of audit or any type of review conducted by the feds or the state, that you're very transparent and you can indicate to those reviewers, this is the account set aside for this business. And really, because, if you are receiving funds from a cannabis industry under federal law, you could technically be exposed to criminal charges for drug trafficking and things like that, because it is your income is related to right now a drug that is a Schedule I drug. I also something to keep in mind if you're a landowner and so you have a mortgage on a property, a lot of mortgages require compliance with federal law. And so if you're leasing the property to a cannabis industry, cannabis company, that could violate, federal law, and so you'd be in violation of your mortgage. So just another thing to keep in mind. And then again, because of that federal law illegal status, you can't be receiving any federal public subsidies for the property. Insurance. So again, a lot of specific types of insurance that are recommended for you to require a cannabis tenant to secure. Starting with the law, so the MMFLA requires medical marijuana businesses to have a minimum 100,000 cannabis insurance policies. So these are specific insurance policies designed specifically for cannabis companies. And for the requirements under the law, this is going to be primarily to cover bodily injuries associated with their business. Additional types of insurance that you might want to require, in addition to the just normal business general liability, coverage for the building, coverage for equipment breakdown, coverage for business property, loss of income, money and securities, directors and officers, cyber and privacy liability, employee dishonesty, glass coverage, computer equipment, finished stock, crops, spoilage, product recall, in-transit cargo, business auto coverage, workers' compensation, professional liability, pollution, and special events. So these are all different types of insurance that you might not normally think of or might not normally require your tenants to hold. But if you have a cannabis company that you're leasing to, that might be something to include in your lease agreement. And with that, I'll turn it over to Karina to talk about trademarks.
So you're probably wondering why trademarks are important as to the leasing or a commercial real estate or real estate professional. Well, just like a realtor has that registered trademark next to it, it's branding is still important in the marijuana industry, and especially in the local level in Michigan, because it is, as we've stated kind of ad nauseum, it is legal at the state of Michigan level. And so in the state of Michigan, that means that you can get a trademark, or a tenant can get a trademark, or a landlord can get a trademark as it relates to marijuana and different marijuana services or products. The federal level, you can't. And so because the USPTO still refuses to register anything that is a clear violation of federal law. So since, as Caitlin mentioned, marijuana is still a Schedule I drug, you can't get anything that directly relates to it. But what we're seeing at the federal level, to kind of take a tangent, is that people are doing a circle the wagons approach, trying to get that logo or that brand name or that store name registered as it relates to other types of services, and seeing if they can get that marked through. There are also different types of allowances if you put something specific on the label, like contains less than 3% or 0.3% THC, then the USPTO will allow that, or hemp, for example. But the reason that it becomes important as a landlord or a tenant is that confusion of branding. And the example that I like to use, and I used it even before Coming to America 2 came out on Amazon or Prime or whatever, was the McDowell's versus McDonald's. You know, those two different types of branding is going to be confusing. And so if you have a tenant that is McDowell's and McDonald's comes after them, they might have to change their logo because of a confusion issue with the public. And so the same thing might happen at a tenant level in the state of Michigan, where you have one established dispensary or grower or processor, and they have somebody else who comes in with a clearly confusing mark, and they're trying to just riff on that brand. And then, you know, you have the signage up, and then all of a sudden, all of that signage has to come down, because not only does the signage create confusion, but that branding and that the logo on the packages or whatever creates confusion. And so you have some potential outside of the building ramifications, in addition to what Caitlin has already mentioned as to odors or traffic and security, etc. But we still always highly recommend that anybody in this industry, if they have that, if they intend to go into that, and then they can clearly establish their brand so that people know where to go, because it is, as most of us have realized, a highly profitable industry, not only with there's the markups, but there's a lot of sales coming through. They're projecting that this industry will grow at a rapid pace. I mean, it has been growing, not to, you know, make a bad pun this morning, but it is something where you're going to see an exponential increase in people getting interested in it, especially when receiving any kind of, you know, if it does open up at the federal level, we are expecting that there will be a lot of interest in this industry. And so it is something to keep in the back of your mind of, okay, who am I dealing with? Is it this entity or another entity? You know, how serious are they about this? And registering things at the state level is very cheap. It's like $55 per. So if somebody's taken those steps, then it just legitimizes that business even more.
So with that, this is our contact information. I do realize that my maiden name is still on this slide, but you can still reach me at caitlin.carr@kitsch.com, or you can reach me at caitlin.elias@kitsch.com. I want to open it up for questioning. While we do that and wait to see if there are any questions, I do want to direct you guys to the Michigan Regulatory Agency website, because one of the things that I'm finding is that some of these transactions are happening really quickly. So say you're a landlord or broker, and you are realize you have a piece of property that's really valuable to these cannabis companies, and they're approaching you and they're like, we'll pay you, this really amazing rental price for this piece of property, and we just need to do this really quickly, right? And so a lot of landlords and brokers are really excited to execute these lease agreements, and maybe they're not doing all the due diligence that they might otherwise do. And so the biggest thing that I'm recommending is that before you enter into any type of real estate agreement with a cannabis company, is really making sure that you know that they are, in fact, a licensed organization. So the quickest thing you can do is just go to the Marijuana Regulatory Agency website and verify their license. And all you have to do is click on verify. It'll take you to their website, and you just have to type in their business name. So type in the entity name, type in, whatever the name that the tenant is trying to sign the lease with, type in their name. Make sure that they have a cannabis license, because if they don't, if they're not licensed, you're really going to get into a place, you can keep them on the hook for the rent, but they're not going to be a successful business. They're not going to be in compliance with state laws. And so the best thing you can do is to really kind of do your due diligence beforehand. Make sure that they have a license. Make sure that they're compliant with all state laws before entering into the agreement. Otherwise, you're just kind of setting yourself up to have a problem tenant. The other thing I wanted to recommend, let's see. There is a website through the city of Detroit that shows all, it's like a map where all of the different compliant real estate properties are and where the zoning is. And keep in mind, the city of Detroit is passing new zoning ordinances that are going to take effect on April 1st that do apply to the recreational use zoning laws. So right now, the zoning laws that are in effect are applicable only to medical marijuana facilities. So they are working on passing the zoning ordinances that are specific to the recreational use. But I don't know, Karina, if you have anything else to add while I look for this website real quick.
You know, it just circles back to being aware of the municipality that you're operating in, or that you have a potential client or tenant who is interested in operating in. What are they doing? What do they intend on doing? You know, are they just kind of saying, hey, I'm really interested in this area because I see that there's a lot of potential for profit, and because that's what we're seeing a lot of people are doing. They're super interested in, but they don't go through and actually do any of the due diligence, and they see the licensing requirements and they're like, oh wait, that's like a lot. And so because of the potential draw, it's very important as a landlord to protect yourself, and that's getting the guarantee, as Caitlin referenced, and being aware of, hey, are they licensed, or hey, what is my municipality require, and just making sure that if you're interested in going into this area, that you're also on top of what is required of your tenants. You can require that the tenant, you know, has all those obligations, but you want to make sure that if you're leasing to somebody, that you are leasing to the right somebody, instead of somebody who's just, you know, fly by night and is going to end up causing you more legal trouble down the road.
Exactly. The best case scenario is that you get a tenant in your property that is a legitimate cannabis company that's operating well, and that you're not going to have a problem tenant then. There's a lot of concerns to be thinking about, and if you get the right tenant in there, though, this can be very profitable for both parties. So what I'm sharing right now is for the city of Detroit, they have this map where you just type in either the parcel number or the address of a piece of property, and you can see, is it in a green zone? Are there any issues that affect it? So for example, this piece of property, it's located on Bellevue. It is technically M4 is a green zone. However, the ordinances require that you have to, in order to be an operating cannabis company, you have to be outside the 1,000-foot radius from a church or from a school. And so even though this piece of property is in this green zone, it's within 1,000 feet of a public school. So that means that, you know, a cannabis company can't operate out of that space. Now we do, you know, see certain zoning requirements that are in effect that aren't always applicable. So for example, right now, there's a piece of property that we're working with a landowner on, and right now it's in a green zone, but it's facing this 1,000-foot restriction from being close to a school, but that school is actually not operating and has been closed down. So we can do appeals to the zoning board to kind of appeal that decision and appeal that restriction, and get that property then so that it is restriction free and we're no longer facing those type of limitations. And then that landowner can turn around and lease that out to a cannabis company. So, you know, there's you know, the cities themselves are trying to make it easier for you to identify where the green zones are, where properties are located. Let's see if I can enter another state. Well, okay, so this map, you can kind of see how far this M4, like this is the area. And there's a lot of there's a lot of warehouses. M2 is another area. So these facilities, you know, if you have property in these areas, you're going to be in the green zone. The only thing that's going to limit your ability to lease out is the distance from schools or churches. And what I'll say is right now there's, I think, over 2,500 churches in the city of Detroit, but these new zoning laws that are going to take effect April 1st require those churches to be registered as nonprofit entities with the city assessor in order to have that 1,000-foot limitation applicable. And so what that does is it actually reduces the number of limiting churches down to around 1,200, because only about 1,200 out of the 2,500 churches are registered as nonprofit charitable entities with the city assessor. So you're going to see some properties open up and become available that weren't available before, just because of that change in the requirement for the churches to be registered as nonprofit entities. So be on the lookout for that. But, you know, again, I mean, you can kind of see like these zones are zones, but then they become really limited just because of the other factors and parts of the ordinance. So something to think about. With that, you know, if anyone has any questions, we're happy to address those questions now. Thank you so much for joining us this morning and being a part of this. It's, like I said, a very evolving industry, but we're always here to help you kind of navigate the ins and outs at both the local and state level.
And no questions from anybody?
That's no
It's
fun.
a lot of information.
A lot of information, and you presented it very well. Thank you very much, Caitlin and Karina. And if there are no further questions, we will tie it up and say thank you very much. Look forward to seeing you this afternoon with Workplace 2.0. The presentation today will be posted on the BOMA website in usually within 24 hours under the Education on Demand. So with that, we thank you very much and have a great afternoon. Stay well.
Thank you, everybody.
Thank you.
You.